New England University. We just became University School of Law in Springfield, Mass. It's easy to say Winnick, it's hard to say with you.
Plus, we have this great acronym, we never ever close, because we never close for snowstorms, and then we don't have that, and then we close all the time.
Cool.
We closed for a week for that.
In October.
In October snowstorm.
But we didn't close the first day.
No. But enough said.
So, we both are actually, I was in the first year legal research and writing program. I'm now in academic support. Jean still is in the first year legal research and writing program. So, and what we're going to talk today is about a model for teaching advanced LRW, which is an elective at our law school. Students are required to take 2 semesters of the first year class, but beyond that, it's an elective. So just by way of background, the first year class, probably the same as many other classes, begin with objective writing in the fall. It's an introduction to legal research and writing. They write a memo, an objective memo. They do what we call a research and report assignment, which is a quick turnaround, incorporates either an email or a client letter and an oral report back to a supervising attorney on the problem, and then another memo with a rewrite. They do persuasive writing in the spring. Generally, we do trial level advocacy in our first year program, so it's a pre-trial setting, typically a summary judgment motion or a preliminary injunction request, but it's simultaneous briefing. Here are your clients, you're on opposite sides, briefs are due on date X, and you're going to argue, which is not what happens in the real world.
And one of the things I think we all try to emphasize, and I'm sure this is true in your classrooms as well, is that we try to simulate real-world legal practice to the greatest degree possible. But the one place where we really do fall down on that is with the simultaneous briefing, because obviously the plaintiff and the defendant, or the moving party and the non-moving party, do not file their motions simultaneously. But because of the structure of the academic year, and also the unevenness that would result if you had one set of students who were the moving party and another set of students who were the non-moving party, putting all the onus for doing the research and creating an argument on the moving party, it would be unfair. So we do what I suspect most of you do, and we do simultaneous briefing. And that, is an unfortunate academic reality. I will say, as a segue before we move on to talk about what we do in the advanced class, is that we are this year bringing back an exercise in our first year program that we have done before, kind of abandoned for a while, and now it's resurging. And that is the first assignment that the students will get when they get back to school in January is we've written a motion to dismiss, or a motion for summary judgment, and the students will have to respond to that motion. So that gives them some of the real world authenticity. But the main reason we're doing that is to model persuasive writing for them in a way that's a little easier at first, because then they don't have to worry about doing the research, as much research, and creating the argument.
It also provides an opportunity to model, piggybacking on what Melissa said in the last hour. It gives us an opportunity to model oral advocacy, because typically what we've done is we've done oral arguments where LRW professors play the roles of attorneys and judge. We bring the students into the courtroom and we argue the case.
Which is a high-stress situation when you're arguing in front of your students and you're afraid you're going to make a fool out of yourself. But.
So what we've done in the advanced class is to do away with simultaneous briefing. I will divide the class into 2 firms. I'll have 2 appellate problems, and I will give each firm an appellate problem. So they begin, they're all writing an appellant's brief. And they write the draft of the appellant's brief, they confer with me, they resubmit their final version, they also serve on a member of the other firm. So everybody writes an appellate brief, and then everybody writes an appellee's brief.
And that has the benefit, obviously, of authenticity, because that's how things would work in the real world. That you would, if you're the appellee, you would respond to the brief. But there's other, and I always say this word wrong, so I'll probably say it wrong, pedagogical, is that right?
Sounds good to me.
Close enough. There's other pedagogical goals that get served by this as well. First of all, they write 2 briefs, which if you believe in the practice model, which Melissa was talking about in the last session, that's certainly helpful. But there's also the collaborative aspects of being a member of a law firm, where you can talk about your brief and the arguments that you are going to incorporate.
Do you guys do a reply brief too, or?
No.
Usually, just fitting it in to the term, I haven't done that. But you know, another time, another year. So there, it's as Jean said, it's good to have the structure of the law firms, and we in a few screens down the road will tell you some of the other opportunities that arise by using a law firm structure. You can use library staff. You could send one firm to meet with a research librarian and talk to the firm remaining, and then flip. There are a lot of opportunities. Oral argument, students argue one of the 2 cases only. They serve on the appellate panel for the other case. So, and their participation as an appellate judge gets evaluated, and that's part of their grade. So I'm always the Chief Justice, and I have 2 co-panelists, and they do a good job, as they certainly know the cases.
Yeah, and that is really helpful in terms of the oral argument, because it's unwieldy to argue both cases, but when you have the students serve as judges, it's really effective, because then they have to think about the case in an entirely different way, and they can ask very searching questions because they're very familiar with the case, so it's very helpful in that regard.
Do they pick the case, or do you pick it for them?
Just random. I mean, I suppose they could. You could have them give preferences and say, I'll honor them to the extent that I can, but if everybody wants to be the judge on this case or argue on that case, you can't possibly. So that's a possibility.
I think I at one point did ask my class for, I don't think we voted, but we talked about which case would be better to do as an oral argument. There was sort of a consensus on one of them.
Other opportunities for additional assignments building on today's theme, when students receive their opposing brief, their appellee's brief, they should review the brief, do some preliminary research, and then they write a client letter to their client. We've received this brief. That's a good check for me to see how well they understand what they've just received. The last time I taught this class this spring, I did some quick turnaround research assignments. They would come in and I'd say, firm A, we've got this client who needs an answer to this question within the hour. Go to the library. Here's a problem. I want you to only use print sources. Or I want you only to use Lexis. Or I want you only to use Westlaw. Or I only want you to use we can't charge this client any money. We don't have a law library. You can only use free or low cost research. So I have a series of those assignments that I've built in.
The other really, I think, great thing about this structure for the class is the opportunity for peer editing. I know when I do peer editing in my LRW class, and I know there's probably people sitting here who are great advocates of peer editing, but it always makes me somewhat queasy for a number of reasons. One, the obvious fear of plagiarism. When you have students who are all working on the same project, and you have them peer edit, and then the whole problem of, you know, who do you put the really good student with? Do you put them with a really poor student, or, you know, how do you do that matchup, and all of that, and, you know, they're very close to the project, and so they may feel like the way they wrote it was a good way. Well, when you have this appellee-appellant situation, you can have them look at each other's appellant brief, and because that's the one that they're each working on first. And the beauty of that is that everybody is kind of familiar with the other firm's problem, because they know they're going to have to write a brief on it, and it's been talked about in class, so they're kind of familiar with it, they kind of know the law on it, but they're not an expert in it. And so that ability to sit down and read somebody's facts and read somebody's argument, and to be able to say, oh, I get it, I know what X case stands for and how it applies to this case, or, you know what, you haven't told me. You know, it really becomes clear, like, I don't get it, you know, what is the rule here? Or, you know, what, you didn't tell me how that case came out. That's a big thing. I've been grading papers lately, and I've been noticing that my students, they tell you all about a case, but then they never tell you the end. You know, how did the court rule? And, you know, so, and that becomes crystal clear when they see it in somebody else's brief, and then hopefully they can go back to their own brief and apply those same lessons that they learned from editing their peer's brief with it. So it really, that can be very effective.
One thing that I've been able to do is, we're fortunate each semester the Massachusetts Court of Appeals sits in our courtroom. And it's usually timed such that, the first year I did this, my husband had a criminal case that he was arguing. So I got his brief, and I went and talked to my students, and I pulled the brief from the DA, and she was able to talk to my students, and they were required to watch the argument. But if you don't have that opportunity, when I've taught evening students, they oftentimes can't get to the school during the day. They can use the Supreme Judicial Court.
Yeah, in Massachusetts, and well, anyone could, even if you're not in Massachusetts, you can go to their website, but the Supreme Judicial Court does record all of its arguments now, and they also put the briefs online. So that's what I did. I guess the timing didn't work out for me with and my husband's a psychologist, so he'd be useless in a lot of this stuff. But he could tell you how they felt about it. You know, I've had them read the briefs and take them apart, you know, to kind of, again, do an edit and then watch the argument. And then
I
they're
did
informed.
that with my husband's brief.
No, that would really be, yeah, that would have.
I had to go home afterwards. Yeah.
Not in front of them anyway.
Right. So other added benefits, it really does provide real insight into real world lawyering. It's a lot of work because you're reading a first edition and a final draft of appellant's briefs for every student, and a first submission and a final draft for appellee's briefs for every student. I guess it's a lot of work for the students too, but to a person, they all seem to appreciate it. Students are engaged in the oral argument process. I already talked about that. The first time I taught the class, I had two problems, one a federal case and one a state law case. So I developed the court rules. Most recently, when I used this model, I had two appellate problems, both set in the First Circuit. So I required that they research and follow the First Circuit rules. I then gave them my adapted rules because I didn't give them the same number of words, and the filing deadlines were different. But it's an opportunity to have them use real rules of court.
Right, and you insist that they find them and they use them. Coming up with the correct problems, the correct pair of problems to use in the setting is an interesting inquiry of itself. The last time I did it, the two problems that I did were really different in the type of brief that the student had to write and the type of research they had to do. One was a pure common law tort liability third-party liability for an accident question, and it was very traditional in the sense that, you know, they had all learned how to do this kind of research in legal writing. And then the other one was, it was a contempt action, which involved the students having to look at both the statute and regulations and court rules. So the research experiences were quite different, and just the type of argument was quite different. I've thought of, if I do this again, of perhaps doing it in using one subject matter. I am personally on the appellate panel in Massachusetts. There are private lawyers who do public representation, and I'm a member of the Children and Family Law appellate panel, and so I do 1 or 2 appeals a year on behalf of either parents who have had their children removed and their parental rights terminated, or sometimes I represent the children. And I thought of doing it where I did 2 issues in a child protection area, just because then it would have, the class would have the added benefit of covering a lot of substance in addition, in a particular topic area, in addition to the writing aspect of it. And it is one of those rare areas where there actually is some employment opportunity around, because they are still adding in Massachusetts new lawyers to the appellate panel.
On the criminal side also, my husband has a flow of really high quality mentees because I steer good students to them.
Right.
But I think it's important to have balanced problems. They can be different, but they should be balanced. The most recent time I taught the class, which was the spring, I had a Title IX problem involving student coach, and the question was he an employee under Title IX such that his nefarious actions could be compensable, or since the girl would have a problem, cause of action, and I did a student speech case. So I thought that they were of equal weight, but on different subjects. Also, it varies your reading if you have different subjects, so that as you're reading and reading and reading, sometimes it's nice to say, oh,
yeah, right. I cannot read another one of of these. So now I'm going to pick one that I know is on the other topic. That helps with the grading. So in all, we have found this to be a very beneficial way to run the advanced legal writing class. We do question if and how this model could be used in first year LRW. I haven't thought of the way in which it could be done to this point, but perhaps what we'll do is let our co-presenters go forward.
We also have an audience member who comes to that.
Oh, you can speak to that?
Well, I actually heard Myra speak about this topic at the Rocky Mountain Conference a few years ago, and I was really excited, and I went home. And in our spring semester first year course, I do something sort of similar. And what I do is, in the first problem, they have to all write a moving brief on the same problem set. Then for the second assignment, they do a response brief. They do the research on the brief without the benefit of looking at the moving parties brief, so they have to do their own open research and work through that. And then right when the day they hand in their research report to me, I give them a moving brief. And sometimes I have actually used a real pending trial court case, so they are actually getting a real attorney's moving brief to work off of, which is very exciting to them and interesting.
Yeah.
Sometimes I just have a research assistant, or even I may write up the brief myself. And so then, but what they get is they have the moving brief to work off with and actually respond to. So it's worked out quite well, and it's been very manageable for them and for me.
And you do, so in the beginning of the semester, they do a brief on behalf of a moving party.
Correct.
And then the second
assignment is a response brief.
Is a responsive brief. And then at what point do you do oral argument?
We don't have an oral
You don't have oral
argument in
argument,
the first
yeah.
year, yeah,
Yeah.
yeah.
Yeah,
So,
but
but you could work it in.
You could do the same thing,
Yeah.
you could pick one of the topics to do.
Yeah.
Have it on graded.
Yeah,
Yeah.
we could do that.
Yeah. Well, that answers that question.